Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. While the nation's attention is on the confirmation hearings where President Trump's nominee to the United States Supreme Court, Judge Brett Kavanaugh, President Trump also won a significant victory in the United States Court of Appeals for the Sixth Circuit on an unrelated but important matter. But because Trump's court victory has received scant attention in the media, I thought I'd spend a few moments on it today. Here's the background. During a campaign event in Louisville in March of 2016, protesters displayed anti-Trump signs, interrupting his campaign speech several times. Each time, Trump said in response, "Get him out of here," or "Get out of here." At one point, Trump also said, "Don't hurt him. If I say go get him, I get in trouble with the press, the most dishonest human beings in the world." Well, the three individuals who attended the rally, claiming they had an intent of peacefully protesting, also claimed they were assaulted by other attendees at the Trump rally in response to then-candidate Trump's exhortations from the podium to get him out of here or get out of here. The plaintiffs sued the attendees who allegedly assaulted them for battery and assault, but also sued the Trump defendants, including Donald J. Trump, for battery, assault, incitement to riot, and some negligence counts. The Trump defendants filed a motion to dismiss as to all counts. The trial court dismissed the battery and assault counts because the court deemed Trump was not vicariously liable for the actions of his supporters in attendance at the rally. The trial court later dismissed the negligence counts on First Amendment grounds, but refused to dismiss the incitement to riot count and certified that refusal for appeal. The appellate court overruled the trial court's refusal to dismiss the incitement to riot count on grounds that the plaintiffs failed to prove critical elements in support of the tort of incitement to riot, including this: that by Trump's words or actions he had incited violent, tumultuous conduct posing grave danger of personal injury. The court focused on the fact that Trump also exhorted, "Don't hurt them." The court held that statement, "Don't hurt them," negated any plausible finding that Trump's words posed grave danger of personal injury to the plaintiffs. How could they if Trump is saying "don't hurt them"? Words have meaning, according to the court admonished, and here Trump was saved by his own words, "Don't hurt him." The court further held Trump's speech is protected by the First Amendment to the United States Constitution, free speech. The court cited Brandenburg v. Ohio from 1969 for the proposition that the government cannot proscribe or forbid the advocacy of the use of force or of law violation, except where such advocacy is directed at inciting or producing imminent lawless action, and is in fact likely to incite or produce such lawlessness. The court stated the hostile reaction of the crowd does not turn protected speech into incitement. The reaction of listeners does not alter the otherwise protected nature of speech. The court noted Trump said the words, his purpose for saying what he said was to quell the disturbance being made by the protesters, or as Trump would more accurately refer to them as the disruptors. The court concluded speech is powerful. Yet as a nation we have chosen to protect unrefined, disagreeable, even hurtful speech to ensure we do not stifle public debate. Well said. The lesson: be careful what you say in public, even if you're a candidate for the highest office in the land. You can be sued if you say anything that could give your opponents even the slightest basis to file suit. In this case, then-candidate Trump was sued because of the first words that he uttered in response to the disruptors, but then was saved by his follow-up statement that they should not be hurt. And of course, ultimately, he was saved and protected by the First Amendment. But he had to take this case all the way up to the Sixth Circuit Court of Appeals before obtaining favorable judgment on all counts.